if the tribunal is with me,
Mm-hmm.
I would like to take a look at this note because it is important, as was enlightened in the case that is similar to this, Deripaska versus Montenegro. A clear offer and a clear acceptance could constitute an agreement on succession, provided that both such documents provide an intention on both parts that that exchange shall have binding legal effect. However, such intention can be established in two ways, one of which is if the notes themselves provide a specific formulation which would serve as a concrete proposal for reaching an agreement that those exchange will be binding. An example of such provision, which lacks in this note here, is a provision that we have in a diplomatic correspondence between the Ministry of Foreign Affairs of Netherlands and the Ministry of Foreign Affairs of Czech Republic. And I will quote, "Your note and this affirmative reply therefore constitute a joint confirmation that the treaties and the other agreements mentioned above have remained in force." However, honorable members of the tribunal, this not only lacks in the note that is before you, but also in the note that Xenera sent. This is to say that there is no a concrete proposal on both parts that the exchange shall have binding legal effect. Another way in which the intention of a state that the exchange of notes shall be binding can be established is if in another manner could be proven. However, the respondent clearly in its official governmental website omitted, and I would like to guide the tribunal to page 50 of case file. Excerpt from the Valdres governmental website. Honorable members, if the tribunal is with me, honorable members of the tribunal, you would see here that the respondent clearly omitted the BIT from its official governmental website. And this is because we do know that Xenera, on its official governmental website, did not omit the BIT, but included the BIT as an agreement applicable between the respondent and Xenera. However, it is relevant, as was again described in the Deripaska versus Montenegro, that it is of high relevance whether both states provide the same status for a treaty, because it shows a shared understanding of the validity of such treaty. This is to say that if claimant relies on the fact that Xenera provided that the BIT is applicable, to that fact should be given a less evidentiary weight, because there is no mutual understanding that the BIT is applicable. In addition, honorable members of the tribunal, and in contrast to established state practice, the respondent in its note did not include a specific list of treaties it wishes to continue to be bound by. And this is important because that would be a clear indication to Xenera to which treaties the respondent wishes to remain bound by. However, the claimant might probably rely on the note that was sent in the Deripaska versus Montenegro and which was later analyzed. The note had the same formulation that you will see here, and if the tribunal is with me on page 13, Valdres official note to Xenera. If the tribunal is with me, I will quote from the end of the line 204. Confirms its readiness to observe the treaties and agreements that have been effective. End of quotation. What is important here is that the claimant might rely on this provision in the note because the same provision is in the note that Montenegro sent to Russia in the Deripaska case, and that provision was later analyzed as a global offer to continuity. However, honorable members of the tribunal, what lacks in the note that I read to you is the word all. In the Deripaska case, Montenegro clearly indicated to Russia that its intention is to succeed to all the treaties and agreements previously concluded between its predecessor and Russia. This is to say, honorable members of the tribunal, that not only did the respondent did not comply with the usual state practice, and this is to provide a list of treaties for clarity to which treaties it wished to succeed to. However, if we would say that maybe the respondent's intention was to succeed to all the treaties and agreements previously concluded between its predecessor and Xenera, then, honorable members of the tribunal, this would also have to be indicated. However, the respondent intentionally omitted such a word, and this is because the respondent's only intention was to merely inform Xenera that it wishes to enter into negotiations at a later stage. And this phrase, readiness to observe the treaties and agreements, was analyzed by Professor Danbury, who concluded that by using this phrase, Montenegro only indicated to Russia that it is willing to enter into negotiations at the future, at a later stage. And the respondent submits that the same conclusion must be reached in a present dispute. In addition, honorable members of the tribunal, even those states who consider themselves that they automatically succeeded to the BITs of its predecessor, such as Czech Republic or Slovakia, in their diplomatic correspondence with respect to succession, they also provided a list of treaties. They provided a list of all the treaties of its predecessor and the other state party for clarity. This is to say, honorable members of the tribunal, with respect to our first argument, that the respondent's note was not a clear offer to Xenera, and by this, the respondent did not wish to succeed to the BIT by this note. Then I would like to guide the tribunal if there are no questions for this part of my submission.
Ms. Koperovich, what is the authority for the proposition that the Vienna Convention is not customary international law?
Yes, Mr. Arbitrator. I was referring to an Article 34 of the Vienna Convention on State Succession with respect to treaties. And I would like to read to you the Deripaska case, Deripaska versus Montenegro, where I'm sorry, did I hear a question from you?
No, continue, please.
Okay, I'm so sorry. And I will start quoting. The tribunal starts by observing that no international tribunal has accepted that there is a principle of automatic succession for bilateral investment treaties. Honorable members of the tribunal, for an international customary law to be formed, we do need the opinio juris and we do need a state practice. However, honorable members of the tribunal, there is not enough state practice for a customary international law to be formed. In addition, as you saw here, no tribunal has actually accepted that there is a rule of automatic, that the rule of automatic succession in Article 34 actually reflects customary international law. This was only accepted with respect to human rights treaties. However, the BIT is of entirely different nature. And this was also concluded. I'm so sorry, I see that Mr. Mario has a question, so.
Oh, yes.
Yes, but only if after you concluded your response to the president.
Thank you. And to continue, in the Deripaska, it was also concluded that the BITs are of entirely different nature. This is to say that when states do succeed to the BIT, they either succeed expressly or tacitly. However, if there is no express tacit consent, there is no customary international rule in Article 34 of the Vienna Convention on State Succession with respect to treaties. Thank you.
Thank you.
Mr. President, partially my question was responded, but my question was whether in order to succeed to a treaty, you need a treaty that provides so, or because you spoke extensively about the exchange of notes not constituting a treaty. So do you need a treaty in order to succeed on another treaty?
Mr. Arbitrator, to make sure that I understood you correctly, can you elaborate a bit on your question, please?
Of course, of course. So my understanding from your statement was that the exchange of notes does not constitute a treaty. So is your position that for a state to succeed, another state in relation to the treaty, the successor state and the other party to the treaty need to agree via a treaty?
Mhm.
Thank you.
Our position, Mr. Arbitrator, is that both states need to, via exchange of notes, agree that such treaties which are, when the succession is in question, which are mentioned in the notes, constitute an agreement on succession. And this is to say that in the note, which treaties are listed, if states do come to a shared and mutual understanding, then we can say, yes, those states actually by agreement, and those two notes are an agreement. And the treaties that are specified in an agreement, then we can say, yes, both states or one state succeeded to to treaties which are in that agreement. However, for this case, we would need either specified some treaties in these notes, or we would need at least the verb all to say, yes, by this exchange of notes, the exchange of notes is an agreement, and in that agreement we have a list of treaties or a provision which would state all the treaties, and yes, then the respondent succeeded to such treaty. However, we could not say that.
Is that all? Any other questions? Okay, then let's move along. Thank you.
And now I would like to guide the tribunal to conclude there is no clear offer on the respondent's part. However, I would like to guide the tribunal to page 14 of the case files, which is Xenera's official note to Valdris regarding continuation of the treaties. If the tribunal is with me, I will again just quickly repeat that in this note, you could not see a formulation that I cited at the beginning, which would serve as a concrete proposal that these two notes actually form an agreement between these two states. In addition, Xenera also omitted to list any of the treaties previously concluded between Arrakis and Xenera, which would then serve as a clear indication to the respondent that yes, Xenera would like to continue the application of such treaties. What is more important is, and I will quote, just a second, line 217 from the end of that line. Takes into consideration the readiness of the Republic of Valdris. End of quotation. Honorable members of the tribunal, Xenera used a non-binding language in this note. Xenera only indicated to the respondent that it takes note of the respondent's intention to enter into negotiations at a later stage. What is more important is, as we said, this note needs to be a clear acceptance. However, honorable members of the tribunal, what we know from the statements of uncontested facts, both states and both parties to these arbitral proceedings agree that after this exchange took place, it was not clear whether the respondent had the intention to continue to apply the BIT. This is to say that had this exchange been clear on both parts as a clear offer and a clear acceptance, then this would not be a problem. However, if the tribunal would consider the respondent's note as a clear offer, then we can at best say that the respondent meant all the treaties and agreements previously concluded. However, the tribunal would see that Xenera, and I will quote the line 220, especially with respect to treaties focused on economic and trade cooperation between two states. End of quotation. Honorable members of the tribunal, Xenera specified its intention, and this is important. Yes, Madam Arbitrator.
Yes, you mentioned before that in your view, according to Article 34 of the Vienna Convention, we have only a human rights treaty that we can apply Article 34 of the Vienna Convention as a customary international law, or I have not understand correctly. So do you think that only that kind of articles we have to apply Article 34 of the Vienna Convention as customary international law, or other convention as well? Because now what you are doing, you are telling us that the economic agreements are not in your vision into the Article 34 of the Vienna Convention. My question was if in between we have other category of treaties. Thank you.
Perkovich, did you get that question?
I will.
Have we lost? We lost Ms. Tadic and Ms. Perkovich?
Yeah.
I think they're not with us any longer. All right, wherever tech support is, we could use it now.
Let me check. Let's pause time at this point.
We've gone a bit over already. But...
Okay, and then we will wait to see when they come back on, and we'll promote them to panelists, and they can resume from that time. I'll probably have some other of my team members reaching out to check. If anyone in the audience does have contact with them and can let us know also, or let them know that whenever they can join, they can raise their hand so I can very easily see them and promote them back on stage. We will wait a couple more minutes, and if not, at the discretion, obviously, of the tribunal, it might be possible to allow the other party to begin their presentation and maybe then potentially go back if after a couple of minutes we don't have any. Oh, there we go. Here they are. Let me bring them back. Let's ensure they're audible first.
We apologize for this. It was the internet connection. We are again so sorry too.
No problem. You're audible again, so then I'll leave it to the tribunal. Time was paused, is my understanding. So you will resume from then.
And Ms. Kuperkovich, we are running overtime largely due to the questions you've been getting. So we would like to move along. Do you recall the question you were answering?
Yes, Mr. Arbitrator. Just tell me quickly, do you want me to continue answering the question and then to conclude my submission?
Yes, please.
Yes. So, Madam Arbitrator, again, apologies on our behalf. As I was saying, to clarify our stance is that we can apply Article 34 to all the treaties. This is the BITs and human rights treaties. However, to this BIT, we cannot apply it because the respondent did not succeed to such a convention. We could apply it as a customary international law. However, since there is no customary international law with respect to the BITs as automatic succession, then we can still not apply this rule. And the prevailing opinion is that there is automatic succession, but only to human rights treaties. That is what I wanted to explain. Thank you.
Thank you.
To come to a conclusion, Xenera's note could not only, because Xenera specified the group of treaties it wishes to remain applicable between these two states, we could only say that this note, Xenera's note, is a counteroffer. However, with respect to the rules of international law and treaty law, if there is a counteroffer, then the respondent must give another note to either confirm this counteroffer or to deny it. To continue to the monetary gold principle, and I will be brief because of the time, this tribunal is precluded from exercising its jurisdiction due to Iraqi's legal interest being the subject matter of the dispute. As was concluded in monetary gold case, if a legal interest of a party who is not a party to the proceedings is the subject matter of the dispute and is a necessary prerequisite to decide the claim, then the tribunal is precluded from exercising its jurisdiction. And I would like to briefly guide the tribunal to IIL resolution on page I'm so sorry, we don't have that in case file. I will read you IIL resolution because Arakis, as the predecessor state, and Valdris have agreed that the issues on state succession to responsibility will be decided according to the IIL resolution. And IIL resolution in Article 12 states that the responsibility for international wrongful acts remains with the predecessor state, which is Arakis. And what is more important, that in IIL resolution, there is in Article 12, paragraph 3, there is an exception, which the claimant might rely on. However, if we do say that this exception is applicable, then the tribunal needs to go to merits. This tribunal needs to decide on Arakis' responsibility, as per Article 12 of IIL resolution. And if we do say that Arakis is not the only one who is responsible and that this exception could be applied, then tribunal would still need to go to merits to decide whether under this exception, Valdris is also responsible. However, under the general rule, the international responsibility for the FPS violation remains with Arakis. Arakis is not a state party to these proceedings. This is to say that because of that, the tribunal is precluded from exercising its jurisdiction. I see that you have a question.
Yes, with the president's permission. So, what is the value in terms of as a source of international law of the IIL resolution? My understanding is that the IIL is a private institution. So, what is the legal authority behind that resolution? Do you have any in terms of state practice?
Yes, Mr. Arbitrator, I do see your concern. However, both parties, and this is the predecessor state, which is Arakis, and the Republic of Valdris, agreed that any matters would be resolved according to the rules of this resolution. This is to say that this resolution is actually really important for the present case because the tribunal needs to respect that agreement, and under that agreement, Arakis is the one who is responsible for the FPS violation, and because of that, the tribunal is precluded from exercising its jurisdiction. If there are no further questions, I will conclude that. I'm so sorry.
Just one quick question. I know we're running late. When it comes to the denial of permission to transfer funds, now at least much of that happened after independence. So does that somehow go back to Arakis as well?
No, Mr. Arbitrator, that denial is only on the respondent. However, as we say, if the tribunal would decide that there is a part of the responsibility on the respondent's part, then this tribunal would still have to go to merits because the general rule says that Arakis is responsible. However, there is an exception, as we said in paragraph 3 of the general rule. However, for the tribunal to decide whether the conditions in Article 3 as the exception are fulfilled, then the tribunal would still need to proceed to merits because of the general rule. To conclude our submission, because the respondent did not expressly or tacitly succeeded to the BIT, then the tribunal lacks jurisdiction over the present dispute because the respondent is not a state party to the BIT, and because under the general rule, Arakis is the responsible for the FPS violation, then this tribunal is precluded from exercising the jurisdiction, and as such, the claim is inadmissible. Thank you.
Thank you very much. All right. Who will go first for claimant?
Mr. President, members of the tribunal, good evening. My name is Anana Najrabia, and alongside my co-counsel, Mr. Alexandre Kahadze, we will be representing Bayern Pro, the claimant in today's proceedings. I will address the claimant's jurisdictional submissions, while my co-counsel will deal with the merits phase. During the following 19 minutes, first, I will demonstrate that in contrast to the assertions of the respondent, the Xenera Arakis BIT has in fact been succeeded by the Republic of Walderis, and therefore this tribunal has jurisdiction to hear the dispute at hand. And second, I will showcase that no indispensable third-party issue arises, and therefore the monetary gold principle does not bar the jurisdiction of the tribunal. To start with our first submission, jurisdictional issues in light of succession to the Xenera Arakis BIT, I will be addressing the arguments raised by the respondent in due order, and first showcasing that succession has in fact occurred explicitly through the exchange of notes. Second, and alternatively, succession occurred tacitly by way of conduct of the parties. And lastly, succession occurred due to the rule of automatic continuity of treaties. Members of the tribunal, to start with our first argument, as stated by the respondents' counsel themselves, as stated in the case of Deripaska against Montenegro, there needs to be both a clear offer and a clear acceptance for a successor state to become bound by the international treaties which have been entered into the force by its predecessor. The respondent directed this tribunal to page 13 of the case files. However, what we would like to showcase in this case and give you our interpretation of the unilateral declaration is that the very fact that the Republic of Walderis stated its readiness to observe the treaties that had been enforced between the Federal Republic of Arakis and the Kingdom of Xenera suffices in itself as a clear offer for becoming the successor in terms of treaties. As stated by the International Court of Justice in the case of Croatia against Serbia, broad declarations are sufficiently specific to be taken into consideration as clear offers. Moreover, this clear offer was thereafter complemented by the note from Xenera. The respondent continuously referred to the exchange of notes between the Czech Republic and the Netherlands, stating that there is some type of criteria to which these notes need to adhere. However, we would like to refer to the commentaries of the International Law Commission, which state that this exchange of notes is not in fact subject to any formalistic criteria, and as long as a positive response is communicated by one party to another, no problem arises. We would like to direct the members of the tribunal to page 14 of the case files. That is Xenera's official note regarding continuation of treaties. And the third line from the bottom of the paragraph, if the tribunal is with me, I quote, is content to continue relations on the already established conditions, especially with respect to the treaties focused on economic and trade cooperation between the two states. End of quote. The tribunal. While the respondent alleged that Xenera did not refer to any specific treaties, it is illustrated in the note itself that the other party showcased its willingness to become a member and a partner in terms of agreements which specifically referred to trade and economic cooperation. Furthermore, to draw the parallels with the case of Deripaska against Montenegro, upon which the Respondents' Council relied extensively, we would like to showcase the difference between the exchange of notes in the case of Deripaska and the case at hand. While the Permanent Court of Arbitration had to analyze the exchange of notes, it stated that words such as takes into account, takes into consideration, or acknowledges are not enough to result in assumption of international legal obligations. However, in the case at hand, we will have wording that is less ambiguous and more specific to the legal commitment of the parties, that is readiness to observe and content to continue relations on the already established terms. And members of the tribunal, this already established terms can be nothing else but all the international agreements that had already existed between the parties, including the BIT in question. Therefore, it is our position that this tribunal should adopt the same approach as has been taken by the tribunal in the Iram case, which established that the exchange of notes in a scenario of a succession of states can in fact have the same legal effects as a ratification of a treaty. Based on the presented arguments, it is the position of the claimant that succession has in fact occurred explicitly through the exchange of notes. And as regards our second argument, this specifically refers to the respondent's contention that there was no way of conduct which would lead us to the conclusion that the parties decided to tacitly succeed to the Xenera-Arrakis BIT. And in relation to that contention, our argumentation would be twofold. First, the public listing of the BIT in question in publicly available databases, and secondly, the continuous usage of bilateral trade agreement and the double taxation treaty by both Xenera and Walrus. To start with our first argument, we would like to emphasize that the BIT has been treated as a treaty in force on Xenera's website as well as the UNCTAD Investment Policy Hub. Members of the tribunal, according to the case of Deripaska, there is a three-pronged test which helps us establish whether or not the public listing should be taken into consideration and given any evidentiary value. And according to the first element of this test, we need to look whether or not the data provided is provided by the states. The Xenera's website is mandated by its own Ministry of Trade, and the UNCTAD Investment Policy Hub operates based on data provided by the states themselves on a voluntary basis. Therefore, it showcases only the treaties which are in force, and after the treaty is terminated, it no longer appears on the UNCTAD Investment Policy Hub. Furthermore, the listing of the BIT in question was consistent over time, and while the respondent tried to showcase Walrus's general willingness of non-succession to the Xenera-Arrakis BIT by referring to Walrus's website, we would like to direct this tribunal to case files, and more specifically, page 77 of the case files, that is uncontested statement of facts. Paragraph 45, and starting from the end of the third line, and I quote, if the tribunal is with me. However, the website appeared incomplete as it only referred to certain types of treaties, end of quote. Therefore, members of the tribunal, when the respondent stated that it showcased its willingness by not including the BIT on its public databases, it misconstrued the facts and intentionally left out one of the most important factual informations. Therefore, it is our position that the public listing of the BIT in question showcased once again parties' willingness to treat it as an agreement in force between themselves. And secondly, in relation to this argument, we posit that the very fact that the countries have continuously applied the bilateral trade agreement and the double taxation treaty in between themselves showcases their willingness tacitly to succeed to the treaties which have been in force between the predecessor and Xenera. In relation to that, we would once again ask the members of the tribunal to follow us to page 88 of the case files. Once again, the uncontested statement of facts, and more specifically, the procedural order number 2, and paragraph 5. If the tribunal is with me, I quote, the bilateral trade agreement between the Kingdom of Xenera and the Federal Republic of Arrakis contains a reference in its preamble to the Xenera-Arrakis BIT, acknowledging the significance of the investment treaty for fostering economic cooperation between the two states. And Members of the tribunal, a factual circumstance of essence here is the fact that after gaining independence on January 1st, 2023, Wilders continuously applied both the bilateral trade agreement and the double taxation treaty in question. Therefore, it is the position of the claimant, and we urge the tribunal to take the same approach as has been used in the case of worldwide minerals against Kazakhstan, where the tribunal had to closely examine the relations between Canada and Kazakhstan and found that by way of conduct, parties had in fact succeeded to treaties. And more specifically, yes, Mr. Arbitrator. I'm sorry, but
you're muted, I think.
You are muted. I don't hear you.
I apologize. Maybe you can incorporate your response as you finish your question. But so can you mention any concrete concrete acts by the respondent upon which you can as an evidence that the respondent has in fact agreed to succeed on the BIT?
Mr. Arbitrator, in relation to that, we would want to again have to refer to the preamble in question and draw a parallel with the case of Canada and Kazakhstan. However, on top of that, to more specifically address your question, we would cite the decision in Deripaska against Montenegro, where the Permanent Court of Arbitration affirmed that the BITs are by their nature dormant agreements, and therefore we cannot establish how they are applied on a daily basis by the parties unless a breach occurs, and thereafter an investor can take its right and go to the tribunal to ascertain its rights under the BIT. Therefore, stemming from the very nature of the BIT, that is the dormant nature, we cannot specifically showcase how the parties decided to apply them on a daily basis in relations between them. And as regards finally, the explicit succession, we argue that in contrast to the arguments raised by the respondent, the rule of automatic continuity has in fact transformed into a part of customary international law and applies to the case at hand. Members of the tribunal, according to Article 34 of the Vienna Convention on Succession of States in respect of treaties, the obligations of the predecessor state ipso facto bound the successor state. In order to establish whether or not a rule has become a part of custom, we need to look for two specific elements, that is state practice and opinio juris, as stated in the case of Libya against Malta. And it is the position of the claimant that both of those two requirements are present in the case at hand. First, we would have to refer to the ILC commentaries, which state that even though there might be several discrepancies, the practice is coherent enough to let us conclude that the states have acknowledged the rule of automatic continuity as a positive rule under international law. And secondly, to further substantiate our argument, we would draw this tribunal's attention to who are the signatories of the VCSST. Among the states are those who have gone through specific complex succession issues, such as the Czech Republic, Montenegro, Bosnia and Herzegovina, Slovenia, Slovakia, etc. And these states have decided to understand the rule of automatic continuity as a part of customary international law, and in fact treat it as a positive rule under contemporary international law. And not only have the states signed the VCSST, they have also used the rule of automatic continuity in their exchanges of notes. For example, to refer to the exchange of notes between the Czech Republic and its international partners, the Czech Republic, after gaining independence, specifically stated that it considered itself to be bound automatically by all the agreements which had been entered into force by its predecessor. And this has also been the position undertaken by the United States of America after the dissolution of the USSR, when the US stated that due to the principles of legal certainty, it does view the rule of automatic continuity as a part of customary international law from the reading of both state practice and opinio juris. If there are no further questions in relation to the first submission, I would like to shortly summarize and once again state that in contrast to the assertions of the respondent, the succession to the Xenero-Arrakis BIT has in fact occurred, and therefore this tribunal has jurisdiction to hear the dispute at hand. Members of the tribunal, to move on to our second submission, it is the position of the claimant that no indispensable third-party issue arises, and therefore the monetary gold principle does not bar the adjudication by this tribunal of the third submission of the claimant. Even though the respondent did not manage to address all the arguments under the monetary gold principle, we will be guided by both their written submissions, which were present in the case files, and stemming from that, addressing due order, that at first, Iraq's legal interests will not form the very subject matter of the decision to be made by this tribunal. And secondly, the cybersecurity incident has already been authoritatively interpreted through the FMH internal audit report, therefore mandating the monetary gold principle inapplicable. Members of the tribunal, according to the well-established principle of monetary gold, a tribunal may not exercise jurisdiction if it concludes that third states' legal interests will not only be affected, but will form the very subject matter of the decision to be made. And according to the ruling of the International Court of Justice, in the case of certain phosphate lands in Nauru, legal interests reach this level when the tribunal has to make a decision upon a third state's legal interests as a prerequisite to making final determinations regarding the claimant's contentions. And it is the position of the claimant that this is not the case here, as to draw the parallel once again with the case of Nauru, the determinations upon Iraq's Walrus's legal interests will not inevitably and at the same time be determinations upon Iraq's legal interests. The respondent has invoked the IDI resolution, which has been taken by the states as a way of settling any succession issues which may arise after the independence of Walrus. And we would like to refer to the specific articles cited by the respondent themselves, more specifically Article 12, Paragraph 1. However, members of the tribunal, Paragraph 1 is a general rule which should not be applied if more specific rules under the very same Article 12 can be applicable to the case. And it is the position of the claimant that in this case, the tribunal should apply Article 12, Paragraph 3, which mandates that the obligations of the predecessor state do not become the obligations of the successor. And more specifically, the transfer of obligations is mandated when particular circumstances so require. Therefore, Article 12, Paragraph 3 allows this tribunal to adjudicate upon the very specific legal obligations of Walrus without touching upon the obligations of the Federal Republic of Arrakis. However, in order to apply this article and result in transfer of obligations from Arrakis to Walrus, two very specific criteria need to be specified. First, particular circumstances should so require, and second, the author of the act, that was the organ of the predecessor state, should have become the organ of the successor state. And it is the position of the claimant that both of those requirements are satisfied in the case at hand. Firstly, to start with the particular circumstances, the circumstance at hand which would mandate the transfer of obligations from the federal government to the Republic of Walrus is the direct link which exists between the internationally wrongful act at hand, that is the violation of the full protection and security standard, and the territory in which this violation occurred, that was the territory of the PHO of Walrus. Therefore, the direct link between the breach and the author of the breach is established, mandating the particular circumstance for application of this article. And secondly, the sole author of the act was the PHO of Walrus. To refer this tribunal once again to the case facts, the PHO had extensive autonomy and more specifically exclusive competences when it came to regulation of its internal systems. Therefore, it is the position of the claimant that the PHO was the sole authority entrusted with ascertaining that the cybersecurity recommendations were taken into consideration. And furthermore, the PHO of Walrus thereafter became the organ of the successor state, that is the Republic of Walrus. According to the facts of the case, more than 80% of its previous personnel was maintained, as well as the core departments and the general policy of the PHO. Yes, Madam Arbitrator.
Yeah, thank you very much. So do you consider that the principle of monetary gold will be applicable in international law and arbitration law all the time, or there are some differences?
Madam Arbitrator, while there is no unanimous consent regarding the applicability of the monetary gold principle before international arbitral proceedings, it is the position of the claimant that even if this tribunal finds that the monetary gold principle is applicable stemming from its previous jurisprudence, for example, in the case of Pildekovics against Norway, the claimant's submissions would still be admissible, as Arrakis's legal interest will not be very subject matter of the dispute at hand. And as I see that my time has run out, may I shortly summarize my submissions if there are no further questions?
One further question. If you know, why did your client not bring a claim against Arrakis?
Mr. President, BioNPro is no longer able to bring its claims directly against Arrakis due to the changes and amendments that have been made by Xenera and Arrakis to the BIT in question. More specifically, after Wilderness became an independent state, they amended Article 8, and the investor no longer has the ability to bring arbitral proceedings against Arrakis itself. And as the Wilderness is the responsible for the act, it is the proper procedure for the claimant here. So to shortly summarize our submissions, I would once again reinstate that first, succession has occurred, and therefore this tribunal can hear the dispute at hand. And secondly, the monetary gold principle does not bar the jurisdiction of the tribunal in relation to the third submission. Thank you.
Thank you. Are we now prepared to go to the merits? Does anyone need a short break? No. All right, then.
Mr. President, if I may.
Oh, that's right. We have the rebuttal. Excuse me. Thank you so much. It is time for a rebuttal and surrebuttal. It's good that someone's paying close attention. So to go to respondent, you have a minute or more for your rebuttal.
Thank you. For this rebuttal, the respondent has 2 points. The first one being that based on, for the treaty to be tacitly consented by a state, there needs to be for each treaty individually concrete acts that would imply that that treaty is tacitly accepted. This is to say that only based on the facts that the double taxation treaty and bilateral trade agreement are tacitly accepted on the respondent's part, that does not imply that the BAT is also tacitly accepted without concrete acts. Our second point is that the claimant could not institute proceedings against Arrakis because Arrakis intentionally removed the clause that would permit the claimant to do so, because Arrakis knew that if the tribunal would go to Article 12, paragraph 3, which is the exception, then the tribunal would have to go to merits and decide on the apportionment of responsibility, and the tribunal would need to decide on Arrakis' responsibility. This is to say the tribunal is still precluded from exercising a jurisdiction. Thank you.
Thank you very much. All right, does claimant have a little surrebuttal?
Mr. President, members of the tribunal, first, the claimant argues that the BITs generally do not produce any visible state practice until a dispute between the parties arises, and this has been the holding by the Permanent Court of Arbitration in the case of Deripaska against Montenegro. Therefore, we cannot refer to the BIT itself for showcasing any type of tacit consent. And secondly, as regards bringing the contentions against Arrakis specifically, the claimant would once again have to reinstate that after the amendments entered into force, BioNPro can no longer bring arbitral proceedings against Arrakis itself, and thereafter, the tribunal is not at this stage of proceedings tasked with deciding upon the legal interests of the Federal Republic of Arrakis, as Article 12, paragraph 3 of the IDI resolution gives it a wide leeway to concentrate solely on the author of the act. Thank you.
Thank you. All right, now it is time to move on to the merits. And Mr. Kaxade, will you be beginning?
Mr. President, members of the tribunal, let me briefly reintroduce myself. As my co-counsel has already mentioned, my name is Alexandra Kakhadze, and today I have the opportunity to represent the claimant, BioNPro Incorporated, in today's proceedings. Members of the tribunal, to showcase our case, we will have two main points of argumentation. First, Article 3 of the BIT regarding full protection and security of the claimant's investment has been breached by the respondent. And secondly, Articles 4 and 5 of the BIT regarding free and non-discriminatory transfer of funds has been breached by the respondent state, that is, state of Valdris. Now, to start with the first issue, that is the breach of Article 3 of the BIT regarding full protection and security, we will have three main points of argumentation. First, full protection and security encompass cybersecurity of the claimant's investment. Second, due diligence threshold under full protection and security has been breached by the respondent state in the given case circumstances. And thirdly, as already partially argued by my co-counsel, articles on the state responsibility and succession to them mandates that the responsibility shall shift to the state of Valdris in the current proceedings. Starting with the first point, members of the tribunal, even though the opposing counsel might argue that traditional interpretation shall be used in each and every case regarding full protection and security, we would argue otherwise. Now, we do not argue that in each case the cybersecurity shall be encompassed within the full protection and security standard. However, there are particular circumstances when the tribunals shall interpret the FPS standard more broadly. And to showcase our point, we would request the tribunal to follow us on page 83 of the case materials. Page 83 of the case materials provides definitions of the BIT. And at the top of the page, under Article 4, under Roman numerals, and I quote, if the tribunal is with me, there are rights in the field of intellectual property, technical processes, goodwill, and know-how, end of quote. In this regard, members of the tribunal, the ICSID tribunal in 2012, Unglaube versus Costa Rica found that if particular circumstances require, the tribunals may delve and diverge from the traditional understanding of the full protection and security and encompass within it other matters rather than physical protection of the claimant's investments. Now, members of the tribunal, definitions of the BIT itself refer to investments as intangible assets. Those are intellectual property rights, technical processes, goodwill, and know-how. As we know from the case facts, the respondent themselves invited Biompro Incorporated into their country. Main type of investment for the claimant was the intangible assets they provided. Those were intangible securities, intellectual property rights, technical processes, etc. We have requested the respondent state to provide required security for our intangible assets, and they have accepted that in our agreement. However, now they're trying to argue that full protection and security shall not encompass the cybersecurity that was very object and purpose of the BIT itself. And we argue that as it was decided in the Unglaube versus Costa Rica in 2012 ICSID decision, which also reiterated the findings of Bywater Gov versus Tanzania, also ICSID decision, in the given circumstances, that the main definition under BIT, which the claimant was using for its investments, was intangible assets, it would render ineffective the full protection and security standard to be interpreted to relate only to the physical protection of the claimants and protected claimants' investments. As it is mandated by Vienna Convention on the Law of Treaties, Article 31, Subarticle 1, we shall look at the object and purpose of an international agreement. And if the object and purpose of Article 3 of the BIT was to protect the claimant's investment, and if the claimant's investment was of intangible nature, it would become illogical for the current tribunal to find that the security of intangible assets should have been only physical. In light of these findings, we request the tribunal to find that full protection and security encompass cybersecurity of the claimant's investment under particular circumstances of our case. Moving to our second point of argumentation, members of the tribunal, we provide that due diligence threshold under the full protection and security standard has been breached by the respondent state in the current case. Now, as it was showcased in OI European Group versus Venezuela, we understand that full protection and security standard is not an absolute one. The respondent states shall not become absolute insurer against each and every harm. However, as it was articulated in El Paso versus Argentina, when the respondent state knows or should have known about a possible injury to the claimant's investment, they shall take proactive steps to defend the protected investor's investments. And it is our position that given the case Yes, Madam Arbitrator.
Yeah, so you mean here that your standards of due diligence requires a proactive attitude from the state for the Valdres? Which
Yes,
is our standard of due diligence? It's only negligence or also proactive attitude?
Madam Arbitrator, as it was articulated in OII European Group versus Venezuela, the full protection and standard is not a protection of the result, but of an action. The actions that the states shall take to protect the claimant's investments. And when the states fail to deliver upon their obligations, either through action or omissions, the full protection and security standard is breached through the due diligence. And it is our position that the respondent state has not taken necessary steps it was required to do so, as they were aware of an upcoming cyber attacks within the GOD member states. Now, as we know from the case facts, since 2013, members of the GOD member states have been undergoing cyber attacks. Since 2016, those cyber attacks escalated. In 2021, GOD issued recommendation to its member states to increase their cybersecurity, as the public facilities of the GOD member states were directly attacked by those unanimous anonymous hackers from different countries. Now, knowing this, the respondent failed to deliver upon their full protection and security obligation. And to showcase our point, we would request the tribunal to once again follow us on page 75 of the case materials, which is uncontested statement of facts. And we would like to highlight paragraph 34. And if the tribunal is with us, we quote third line from the top, starting with the report determined. And I quote, "The report determined with a very high level of probability that the hackers broke into the FMH's IT systems through the systems of the PHO of the province of Valdres, which were not adequately protected. They featured insufficient IT equipment and cybersecurity systems." End of quote. Now, members of the tribunal, the report, which was conjoined by the Federal Ministry and the Provincial Health Authority with a very high level of probability, showcased that the due diligence threshold was breached within the PHO of Valdres, as the attack came from the territory. Now, even though the respondent might argue that there are divergent reportings internal audit of the PHO of Valdres, it is our position that from the two reports we have in the case files, one of them being report of the Federal Ministry, which showcased with a very high level of probability that attack came from the PHO of Valdres, and then we have internal audit of Valdres itself, the tribunal shall give weight and take into consideration only the Federal Ministry's audit report for two main reasons. First, Federal Ministry's report was provided in cooperation with the PHO of Valdres, whereas PHO of Valdres report was provided by them themselves, and the Federal Ministry did not take part in its conduction at all. And secondly, the Federal Ministry's report was provided 8 days after cyber attack, that is on 29 December 2021. However, the internal audit report, which the Respondents' Council might rely upon, was provided 2.5 months after the actual cyber attack took place. As the Crown Tribunal is dealing with the facts and the responsibilities of the state based on balance of probabilities, as it was showcased in the case of Fuchs versus Georgia in 2010 by ICSID Tribunal, the Tribunal, if it finds that the current circumstances were more likely to have happened rather than not, then responsibility might be found on the respondent state. And it is our submission that, taken into consideration that Federal Ministry's audit report was provided in cooperation with the PHO of Valdres, it pinpointed PHO of Valdres with a very high level of probability as the point of breach for the hackers. On the balance of probabilities, the due diligence threshold was breached by the PHO of Valdres themselves. To move on to our third point of argumentation, we argue that under agreed upon rules to international succession in relation to international responsibility, that is the IDI Resolution 2015, the responsibility for the alleged breaches in this case shall be shifted to the state of Valdres. Now, members of the tribunal, as this resolution is newly devised in 2015, we do not have a case law. However, what we do have is an authoritative interpretation of those articles by Professors Cohen and Danbury. And we have to highlight that Professor Cohen was the chair of the drafting committee of the 2015 IDI resolution itself. And in the 2019 commentary, Professors Cohen and Danbury state that if the organ of the predecessor state becomes an organ of a successor state, and as my co-counsel has already argued, this has taken part, and if particular circumstances so require, the responsibility stays solely with the successor state. And it is our position that, as this commentary mandates, if particular circumstances is the territorial link between the alleged breach and the final damages, then the responsibility might be shifted to the successor state. And as the Federal Ministry's audit report showcased that the territorial link was the PHO of Wildris Systems, then the particular circumstances so require under Article 12, Subarticle 3 of the IDI resolution for the responsibility to stay with the state of Wildris. If the tribunal does not... Yes, Mr. Arbitrator?
Thank you very much. It is my understanding that the International Law Commission is also working on the issue of, on the same subject matter as the IDI. Does the work so far carried out by the International Law Commission support the conclusions reached by the IDI?
Yes, Mr. Arbitrator. Exactly the commentary we have referred to right now by Professors Cohen and Danbury in their footnotes to the findings which we have reiterated before the tribunal refer to International Law Commission's Special Rapporteur's second report regarding the succession to international responsibility, and they are basing their argumentation in the 2019 commentary regarding IDI resolution on the findings of International Law Commission's Special Rapporteur's second commentary. Therefore, it is our position that responsibility in the given case shall stay with the state of Wildris. In conclusion, it is our position that full protection and security encompass cybersecurity. Secondly, the due diligence threshold was breached by the respondent state. And thirdly, the agreed upon rules of state succession to international responsibility calls for the responsibility of the state of Wildris in the given case. Moving to... Yes, Mr. President.
Mr. Haxade, how do we reach the conclusion you want us to reach on the cybersecurity issue without reaching a conclusion as to the extent, if any, of the predecessor state's responsibility?
Mr. President, our main point of argumentation is that there was no part of liability from the predecessor state, and the full liability for the commission and omission of those actions were done by PHO of Wildris. Therefore, there would be no need to dedicate or decide upon the responsibility of the predecessor state, that is, state of Arrakis.
But if we disagree with you, then won't we be deciding that Arrakis has retained at least some degree of responsibility?
Mr. President, if the tribunal disagrees with our current position that there is no liability of the state of Arrakis, the monetary gold principle would not bar the submissions on the non-discriminatory and free transfer of funds, which is our fourth issue and which we will argue in due regard.
Please proceed.
Yes, Mr. President. With regards to the second issue, it is our main point of argumentation that first, the Article 4 of the BIT regarding free transfer of funds was breached by the respondent state, and secondly, any justification the respondent state may invoke under Articles 6 and 7 of the BIT regarding prudential carve-out and the exception clauses shall not be applicable to the current proceedings, as the application of those mechanisms by the respondent state was in a discriminatory manner which bars them from invoking those justifications. Starting with the first point, members of the tribunal, as it was showcased in Air Canada versus Venezuela, when a state postpones neither declining or accepting the repatriation request, this in itself amounts to the breach of the free transfer of funds provisions within the BIT. Now, we have made our first request for repatriation in May 2023, and to the date of these proceedings in 2025, the respondent state neither has accepted nor denied our repatriation requests, which, as the argumentation was in Air Canada versus Venezuela in 2021, is a breach of the free transfer of funds within itself. Moreover, even though the respondent state might argue that those breaches were caused by the claimant's own actions, we would argue otherwise. Members of the tribunal, even though the respondent state requested additional information requests 3 times throughout 1 year, it is our position that their third request of additional information was an arbitrary one. Now, let's take a step back and look at the bigger picture. We made our first repatriation request in May 2023, and only in their third additional information request after 1 year in May 2024 did the respondent state request the claimant to change the font of the application and line spacing to 1.5. This is exactly an arbitrary action which was decided upon in the Cristalex versus Venezuela 2016 exit decision, where tribunal stated that actions of the respondent state are arbitrary within their nature if they are not based on legal standards, but on excess of discretion, prejudice, and personal preference. Now, members of the tribunal, when the respondent state could have requested from the claimant to change their font in previous 2 additional information requests, but only did they do so in May 2024, 1 year after our initial request, showcased their arbitrary conduct. And to move on to our second part of argumentation, any justification invoked by the respondent state in relation to the Article 6 or 7 of the BIT shall be barred inadmissible to the current tribunal. As we know from the Article 6 of the BIT, it directly states if the application of the measures by state is discriminatory, the state cannot invoke Article 6 itself. And Article 7 of the BIT under Subarticle 2 states that if the actions of the state go against the BIT itself, then states cannot invoke Article 7 either. Now, one of the articles under BIT is Article 5, that is most favored nation treatment and non-discriminatory clause. And it is our position that respondent breached the non-discriminatory clause under most favored nation treatment. As the cases in the SD Myers versus Canada and Pope and Talbot versus Canada have decided, the main test to find responsibility for a discrimination by the respondent state is a likely circumstances test. And the tribunals in those cases stated that the main comparatory to be found between different foreign investors or of the foreign investor and the national investor is the likely circumstances of their same business and economic sector. And the tribunals in both cases emphasized. Yes, Mr.
A question about the prudential carve-out, Article 7, in particular paragraph 2, where it says that where such measures do not conform with this agreement, they shall not be used as a means of avoiding the parties' commitments or obligations under this agreement. I'd like you to explain to me how that language works with the rest of Article 7, such that Article 7 does anything at all. If you read that language literally, it almost seems to say, well, if you're violating, if the action were taken breaches any part of this agreement, then the prudential carve-out doesn't apply. You don't need the prudential carve-out unless the action would breach some part of the agreement. Explain this article to me, if you would.
Mr. President, we shall look at the substance of Article 7, Subarticle B. It is the financial security and integrity of the party's financial system. Now, if the respondent state invoked Article 7 in relation to free transfer of funds, that would be understandable. However, Article 5 is a non-discriminatory clause, and Article 7 cannot override Article 5 in the given case circumstances to state that states can take actions against the investors within the same particular circumstances. And as I see that my time is running out, may I request the tribunal additional minute to sum up my submission?
Of course you may.
Thank you, Mr. President. Therefore, it is our position that as it was argued in the SD Myers versus Canada and Pope and Talbot versus Canada, the likely circumstances test mainly relates to the same business and economic sector of different foreign investors. And in the current circumstances, we have 3 companies, Wheels, Ecovista, and Biompro Incorporated, all of which are acting within the same sector, that is the healthcare sector. However, the respondent state neither accepted nor denied only Biompro Incorporated's repatriation request, which showcased a clear discrimination against the Biompro Incorporated national of Xenera. In conclusion, we request the respectfully tribunal to find that first, the succession has taken place and it has jurisdiction. Second, monetary gold principle does not bar the hearing of the third issue regarding full protection and security. And lastly, Articles 3, 4, and 5 of the BIT regarding full protection and security and free and non-discriminatory transfer of funds has been breached. We rest our case. Thank you.
Thank you. All right. Does respondent have something they would like to say in response?
Yes, Mr. Arbitrator. Mr. Presiding Arbitrator, honorable members of Tribunal, good evening. My name is Sara Tadic, as already highlighted by my co-counsel, and I will address two substantive issues on behalf of respondent, the Republic of Valdres. Members of the Tribunal, claimant failed to understand two very important things. First, that the respondent was not obliged to provide protection against cyber attacks, and second, that it actually did provide adequate protection against it. To demonstrate this, I will make two submissions. First, that the respondent has not violated the FPS standard under the BIT, and second, that the respondent has not violated the non-discriminatory and free transfer clause under the BIT. Regarding my first submission, I will address three supporting arguments. First, that the claimant's investment is not protected under the FPS standard. Second being that the respondent acted with due diligence. And third one being that the responsibility lies with Arakis, which will match the structure of my opposing counsel, therefore. Regarding my first supporting argument, members of the Tribunal, the Saluka versus Czech Republic Tribunal cited that the full protection and security clause, and I quote, is not meant to cover just any kind of impairment of an investor's investment, but to protect more specifically the physical integrity of an investment against interference by use of force. Therefore, members of the Tribunal, the FPS standard does not encompass just any kind of protection, but the physical one. And since the opposing counsel also stated that the tribunals referred to the definition of investment, for example, in the case of Siemens versus Argentina, the tribunal did that only because the FPS clause contained the qualificator legal, and therefore that was posed as the ground for broadening the scope of the FPS standard. We do not have such clause in this very case. We have standard traditional drafted clause, full protection and security was the wording. Therefore, the tribunal in this very case should then apply the traditional meaning of the FPS clause, which is just protecting physical integrity of the investment. Also, the intangible investments are protected under this very standard, but just their physical parts, the tangible parts of intangible assets, which are hard drives and servers. And here, in this very case, it is an uncontested fact that there was no damage done to those hard drives, servers, or other types of claimant's investment in this very case. Also, the claimant had other assets that were present in the territory of the contracting party, which is also the wording of the clause. Therefore, other assets like laboratories and also production facilities could be protected under this clause, and therefore the incorporation of it under the BIT made sense. Regarding my second supporting argument, that the respondent acted with due diligence, I would like to agree with the opposing counsel that the FPS standard is one of due diligence, as confirmed by many tribunals, Techmit versus Mexico and Saluka versus Czech Republic. In AAPL versus Sri Lanka, tribunal established that due diligence requires, and I quote, reasonable measures of prevention which a well-administered government could be expected to exercise under similar circumstances. Members of the tribunal, the measures that are reasonable under the circumstances are those that are listed within the GOD recommendations. Here, the GOD member states were subject to cyber attacks of the same intensity for years from the same source. They implemented the measures and then transposed them into the GOD recommendations. Therefore, those measures that are listed within this document are reasonable under the circumstances. Therefore, we submit that the respondent applied all the measures in question regarding the GOD recommendations. First of all, we hired the Cyber Guardian SA to apply the security steps to protect the investment of the claimant in this very case. We also trained the employees both on virtual training of the federal government and the Cyber Guardian SA's training. And we also implemented all cybersecurity measures from the GOD recommendations like encryption, access controls, and periodic security audits. Therefore, since also the opposing counsel stated that the report of the FMH stated that the analysis of the FMH led to the conclusion that there is a high level of probability that the PHO systems were firstly infiltrated. We are here to contend that fact that although the FMH report was done in cooperation with the PHO, this does not mean that the respondent agrees with everything that is highlighted within and presented within those reports. Therefore, since the tribunal has before it two contradictory reports, one of the FMH and the second one of the PHO, the respondent is of opinion that that both reports should be given the same evidentiary support. Therefore, we submit that the tribunal here in this very case should analyze measures that the respondent applied and compare them with those that are listed under the GOD measures, and then conclude for themselves if they are applied or not, since those reports that both institutions made are contradictory to each other. Okay, I thought that someone's microphone was open and that Madam Arbitrator was supposed to ask me the question, but sorry for that. Regarding my third supporting argument, the responsibility lies with Arakis in this present case. The Article 12, paragraph 3 of the IAL resolution highlights that two cumulative conditions needs to be applied in order for the exception for the responsibility to be transferred to the Republic of Valdres in this very case. For the convenience of this tribunal and for the benefit, I would read the Article 12, paragraph 3. It states, if particular circumstances so require, the obligations arising from the commission of an internationally wrongful act by the predecessor state pass to the successor state when the author of the act was an organ of a territorial unit of the predecessor state that has later become an organ of the successor state. Members of the tribunal, as highlighted also in the commentary that my opposing counsel stated, authored by Cohen and Danbury, two cumulative conditions are highlighted. Firstly, the structural and organic continuity between the PHO of Valdres and the Ministry of Health should be present. And the second one, particular circumstances need to be present in this very case. In the commentary, Cohen and Danbury stated that one of those particular circumstances is the significant autonomy of the predecessor organ that should be taken into consideration. Therefore, we submit that both cumulative conditions are fulfilled in this present case, since there was the structural adaptation needs to be adopted in order for the in order for the PHO to become Ministry of Health of Valdres, and such structural adaptation needs to reflect the expanded responsibilities of the ministry. And it was not only the barely renaming of the institution, at least one of fifth of the personnel did not continue to work within the same organ, and also the structural adaptations also are present in this very case. Therefore, it is not the same organ, since also it is not the same as the organ would be the one that was under the exclusive competence of Valdres. For example, if the territorial organ was in education, for example, that would be the exclusive competence on Valdres. And if that organ became Ministry of Education, then we would have complete structural continuity. Here, we do not have such a thing, since the certain expansions of responsibilities are present in this very case.
Ms. Tadic, a quick question.
Yes, Mr.
Paragraph 4 of Article 12. Why doesn't that indicate shared responsibility between Acaris and your client?
Paragraph 4 of Article 12.
Yes, well, this is when the international wrongful act committed before the date of succession of states are assumed by the predecessor and the successor state or states. Why doesn't that indicate shared responsibility between the two states?
Mr. Arbitrator, here we submit that the paragraph 3 applies as an exception to this very rule. However, we submit that the Article 12, paragraph 3 refers to also in some manner to possible shared responsibility. However, in Article 12, paragraph 5, we will have some additional aspects from the situation that we need to cover in order to encompass all the facts of the case and see what portion, in what percent is the proportionality of the responsibility. However, here we submit that that's not needed since the Article 12, paragraph 3 applies and the responsibility shifts to, does not shift to Valdres. Therefore, with this, I would like, if I cannot be of further assistance to the tribunal, and if there are no further questions, I would like to go to my second submission. Second submission is that the respondent has not...
Excuse me. My apologies. I probably raised the hand too late. The international law.
Mr. Arbitrator, can you repeat the question here? I didn't hear your question.
Yes, a general international law question related to the status. You refer to due diligence as the applicable standard, but what is the status under international law of due diligence?
Mr. Arbitrator, the due diligence is one of obligation of means and not of result. And here we submit that the respondent in this very case was to apply all the reasonable measures under the circumstances, and that...
Excuse me, no, my question, if I may interrupt, my question is, what is the status? Is it a customary rule? Is it a general principle of law? What is the status of due diligence under international?
Mr. Arbitrator, we submit that due diligence is the customary international law under the international law, and therefore is applied within the FPS standard and also beyond it, even if the FPS standard was not included in the BIT in question. However, here we have the BIT that refers to the FPS clause and therefore encompasses the due diligence obligation within the interpretation of the clause itself. And here we submit that the reasonable measures are those that are concretely in this case are forming the due diligence obligation. So to go to my second submission, to move to my second submission, there are two arguments that I want to present. First one being that the respondent has not violated free transfer clause under the BIT, since it was fully justified under Article 7b, and second, that the respondent has not violated the non-discriminatory treatment clause. Regarding my first argument here, the measures that the respondent implemented are fully justified under the Article 7b, which means that they are taken in order to save the stability and the integrity of the financial system in question. The WTO panel in Argentina Financial Services stated that there needs to be a rational relationship between the cause and the effect of the measure and the prudential objective. So here, the prudential objective is safeguarding the financial system and its integrity and its stability, and the measures that are in question are those prescribed under the Decree 183 and the National Law 48. I would like to guide tribunal to page 93 of the case file. That is procedural order number 3, paragraph 11. If the tribunal is with me, I would like to read that paragraph. The monetary measures introduced under Decree number 183 and National Law number 48 were adopted as a temporary response to the monetary crisis in Valdres. Intended to be temporary, both instruments were part of an emergency package to stabilize the national currency and restore financial balance. As it can be seen, the reason why the measures were adopted is the safeguarding of national currency and its economy. Therefore, there is a direct link between the measures that are applied in this particular case and also the prudential reason that under Article 7b is highlighted. Therefore, also National Law number 48 was designed to guarantee sufficient amount of foreign currency in the state's treasury and to allow the central bank to control the drop of value of the Bulgarian dollar, which are all the prudential reasons and are and the measures are taken in order to safeguard the economy and stability of the economy. About the supplementary request from the central bank in Metalplar tribunal, in Metalplar case, considered that to prove the breach, the investor firstly needs to comply with the procedure. In this very case, all the documentation that was needed, supplementary documentation that was needed for the claimant to resubmit and submit was necessary in order, for example, the list of the countries where the transfers are headed was reasonable indeed and relevant in this very case, since the bank needs to check the legitimacy and end user of the transfers that are headed abroad. Therefore, all of those requirements, all of those documents that the central bank required claimants to submit are in order to protect and to comply with anti-money laundering standards and also countering financing of terrorism. Therefore, those international standards led central bank to request the claimant in these proceedings to submit additional documentation. Also, regarding the second argument on this point is that the respondent has not violated the non-discriminatory treatment clause. Article 5, paragraph B is located on page 84 of the case file, if the tribunal would follow me there. I would like to read paragraph 2 of the Article 5. Each party shall accord to investors of the other party and to covered investments treatment no less favorable than that it accords in like circumstances to investors of a third country and to their investments with respect to operation in its country, in its territory. Members of the tribunal, in this very case, the like circumstances are not present. The tribunals in UPS versus Canada and Grand River versus USA established that investors in like circumstances are in like circumstances when they operate within the same, on the same market, within the same market share, and are subject to the same regulatory requirements. The two companies that the claimant highlights are Coolius Incorporated, which is a medical device producer, and also Ecovista Ltd, a vitamins producer, are not competing for the same market and for the same market share, since those products are not pharmaceuticals. The vitamins and homeopathic drugs are not cannot be substituted with medicine. They are not interchangeable goods, and therefore they are not competing on the same market. Also, should the tribunal conclude differently, in any case, they are not subject to the same regulatory framework. And as I see that it remains 20 seconds of my speech, if I can request an additional 30 seconds to conclude my speech.
Please, go ahead.
Thank you. Therefore, those two investors in question are not in like circumstances as the claimant, since they are not in pharmaceutical industry and pharmaceutical sector, and they are not subject to National Law number 48. And that's the reason that why the central bank approved their request for transfer, because the limitations are not, they are not subject to the limitations under national law. And with that, I would like to conclude this submission and request this tribunal kindly to declare that respondent has not violated Articles 3, 4, and 5 of the BAT. Thank you.
May I ask one quick question?
Yes, Mr.
Explain, please, the provisions of national law relevant to the transfer of funds that apply to the claimant here, but did not apply to the other companies you discussed.
Mr. Arbitrator, the national law is applicable only to the entities, to all the entities that work in pharmaceutical, mining, and agricultural sectors. The position of the respondent is that those two producers are not entities that work in pharmaceutical sectors, and therefore they are not subject to the requirements under the national law, which is that they cannot transfer amounts of transfers abroad in some certain amounts, so exceeding, for example, $150,000 per year. And that was only the regulation. According to the national law, the regulation was posed only to the entities working in those three sectors, and the investors are not, the entities are not working in those sectors.
Why is the national law itself not discriminatory?
Mr. Arbitrator, the emergency and the economic crisis that struck Valdres in this very case needed it to consider what measures would be the most applicable in this case and would make to the immediate results. Here, the decree that introduced the authorization of the central bank was directed to all the entities. However, when the requests were coming, the transfer of funds were only the numerous transfers that were requested were from those industries, and therefore the transfer of funds and profits abroad would lead to the collapse of the economy, and that's why it is only limited to those industries.
Thank you very much. All right, we now have a minute for rebuttal from the claimant. Would someone like to have something to say for claimant?
Mr. President, members of the tribunal, we will have one simple point. Respondents' Counsel is contradicting themselves in relation to articles of state responsibility and their succession. They themselves have stated one of the particular circumstances for Article 12, Subarticle 3 to be triggered is an extensive autonomy of the successor state, and they have accepted that PHO of Valdres had an extensive autonomy. Therefore, particular circumstances so require for the responsibility to be shifted to the Valdres state, not to stay with the Iraqis. And moreover, Article 12, Subarticle 5, as they have stated, might have applied conjointly with Article 12, Subarticle 3 regarding shared responsibility, which is simply not true. Article 3 relates only to the shifting responsibility fully to the successor state, and Article 5 of the same Article 5, Subarticle 5 of Article 12 relates to the shared responsibility. Therefore, we shall not mix them. Thank you.
Thank you. Respondent, any rebuttal?
Yes, Mr. Arbitrator, one point on rebuttal. The sufficient autonomy does not exist under the PHO did not exist. And since the concurrent competencies of the federal government were present, and it was up to Iraqis to set the standards in this very case. And within this field of the healthcare, it was not sufficient autonomy to say that this was the job solely done by the PHO, and those PHOs were formally subordinate to the FMH and Iraqis. Thank you.
All right, very good. I think that brings us to a conclusion. I thank you all for these excellent presentations. I'm sure my other members of the panel agree. These were just superb presentations on both sides. I'm not sure what we're going to do. At any rate, I think it's time for the arbitrators to go to some other virtual place. and Mr. Levy here is going to do that for us, I presume.
Absolutely. First of all, thank you very much to the teams and to the tribunals. Very outstanding presentation. I think everyone...
dear colleagues, dear arbitrators, and I had the possibility to listen a bit, dear coaches, and above all participants. It's a great pleasure for me to join you at the conclusions of this year's competition, although only virtually, and I'm really sorry for that. I hope that next time will be in person. But on behalf of UNCITRAL, I wish to extend our sincere congratulations to all of you, whether or not your team's name appears among the final rankings. I know that this sentiment is often repeated, whether or not your team appears, your team's name appears among the final rankings, everyone is a winner. And I think it doesn't help you if you are not a winner tonight. It wouldn't help you probably, but this is truly what I do think, because you have all participants have taken part in an intellectually demanding and globally connected exercise that mirrors the realities of international dispute settlement at the highest level. Moot court competitions like this one today is, from our perspective, very important because it bridges theory and practice. So this gives students a chance to engage directly with the complexities of international investment law and to explore key UNCITRAL texts that shape this field. And in particular, today, the UNCITRAL rules on transparency in treaty-based investor-state arbitration, which featured prominently in this competition. And from our perspective, they are a cornerstone of efforts to make investment arbitration more open, more accessible, and more accountable, and thereby responding to one of the fundamental criticisms we hear currently towards investment arbitration. And seeing that these principles are argued and tested by the next generation of lawyers is especially rewarding for us, especially on a Sunday night when one might also think of doing other things. As you know, UNCITRAL's Working Group 3 continues its work on investor-state dispute settlement reform. We are continuing to develop concrete texts and tools with the aim to make the system fairer, more efficient, more inclusive, more balanced. And we try to adopt a number of reform elements. We have a number of reform elements that we develop in parallel, and we try every year to adopt those reform elements that have been ready and fit for adoption. And this year, in 25, we did adopt the UNCITRAL toolkit on the prevention and mitigation of international investment disputes, which is a practical resource to help states and investors address potential disputes early before they escalate. So before they are ripe to be part of a moot case, so to say. And although the toolkit was not mentioned in this year's moot problem, it represents another step forward in the ongoing reform processes, and it could somehow inspire future moot cases. We have to see how prevention could feature maybe in the 2026 case. Beyond the legal reasoning and the advocacy spirits, which I could partly witness with the last panel I could join, this really shows that what makes this experience so meaningful, and it's the spirit of collaboration, it's this exchange of contradicting opinions among teams across regions, between academia and practice. And this is what we do experience as well in our working groups. This is somehow the heart of UNCITRAL, trying to build to work with existing texts which have been developed by consensus. So we do invite every working group, we do invite 193 states. And the goal is, and this is what this competition is all about, strengthening the rule of law, try to settle dispute peacefully and try to not resort to violence or other means, but try to, via the argument, find a good solution. So promoting cooperation through law. So let me think by thanking the organizers, by thanking the coaches, the arbitrators, and all those who contributed to making this event possible. And to all participants, once again, congratulations to each of you for the hard work you have put into this moot case, also for the creativity in developing the arguments on the basis of one case which is clearly defined. And I think one could say thereby you showed the professionalism we need also in the future from our legal community. So we at UNCITRAL, we very much look forward to continuing this partnership, to seeing many of you again, and perhaps in the very rooms where the next generation of UNCITRAL instrument will be negotiated. And you may know that we had a working group on dispute settlement, working group 2 on dispute settlement last week, which was on the question how to enhance the reliance on awards in electronic form. We will have one working group next week on electronic commerce. So in that sense, work is ongoing, and this is why we also hope that our cooperation is ongoing, because we will issue on a regular basis new texts developed, as already said, by consensus. In that sense, thank you very much for allowing me to greet you, and congratulations to all again, participants and organizers. Thank you.
Thank you very much, Judy, for being here again on a Sunday, and a lot of truth. Please do stay in touch. UNCITRAL has a lot of very interesting work ongoing, and will always have. And in your future professional careers, have a look. They have a lot of texts, a lot of guidance, a lot of different documents that are very interesting. Thank you very much, Judy, for being with us. And with that, we can now move to, I think, one of the most important things here, if not the most, which is we have concluded very much successfully the InterLaw Cup. We're, of course, waiting for the decision of the tribunal on the final, but we've concluded this moot court experience with 100% full tribunals, no truncated tribunals, no tribunals that were not of 3 members at all, and that would not have been possible without the commitment of many arbitrators, some of which woke up very early in the morning, went to sleep very late at night. But also, if this would not have been possible without a fantastic organizing committee. So before we do anything else, I want to invite on stage, I have already partnered Belen Pauleta with me, but I want to invite on stage, and I know they're on the backstage, they must be hearing, they have to be hearing. So I want to invite on stage.
Look for them.
Sorry?
I'll go look for them as well.
Oh, well, please do. I want to.
Okay. Mario, would you like to begin?
Of course. Thank you very much, Tom. And let me say, first of all, what a pleasure it was to listen to both teams. And I only wish that when I was starting like you in this career, I had the command of international law issues that are so interrelated, and but all of which are very necessary in order to respond to address cases in real life. So I really congratulations on your performance and the research that you clearly did before for this competition. I would like to also highlight or acknowledge the efforts in responding to questions that were on purpose on my side to test a little bit how would you handle international law questions that were not necessarily that were relevant, but were not necessarily perhaps in your dossier. And perhaps take this opportunity to give you a couple of feedback when it comes to questions to both teams in relation to questions that I asked. One is that it is very important, in my view, that you are sure about the responses that you give. At least in one of my questions, the response, I wouldn't have been that comfortable in asserting a response of the sort that you gave. under general international law. And so I think it's important when you are not 100% sure on the response to perhaps say it in such a way that that gives room for discussion, and also to particularly when the response was not in fact necessary for the resolution of the case at hand. So there were other matters that were more dispositive of the case than more dispositive of the case than responding to my question. So, and perhaps the other issue is the importance of actually responding to a question posed by an arbitrator. It is of course a matter of strategy not to respond, in particular when is contrary to your own position on the case. But yet it is important to respond, even if you do that indirectly, or even if it is, even if then you take the step of rebutting what is the direct response. But it is important not to avoid altogether a question that is posed to you. So with that, I pass it to you, Thomas, for any additional comments, or Julia, as you may decide.
All right, Julia, what more would you like to say?
Thank you very much, Thomas. It was a pleasure for me to be an arbitrator here in this competition, and I appreciate a lot the level of preparations of both teams. And they have self-educating themselves in their own roles. I think this is very important because you have so many competitions nowadays, and the students, they have the opportunity to prepare themselves for their future, either in principle for their future in being a lawyer or a counsel, whatever. And it's important, and both teams, they show this. They have done a lot of legal research. The way that they have handled this legal research was different. I encourage all the teams there to research outside the very demanding legal questions that are in such a case, because if you don't research outside a lot, you will not be in place to answer properly. But also for your general culture, legal culture, is very important to participate to such a competition and to have the proper legal education to win a prize, and not only to know how to play the best counsel. I think this is something that all of you have to keep in mind. Regarding the feedback to my question, I think it was a good feedback for the both teams, and they show a reasonable way of understanding the questions. It's true also that I didn't have very difficult question, because I wanted to see how the team will expose their points of view on their pleading, and also to complete to my colleagues. So again, congratulations to both of you, and good luck with the future activities.
Thank you, Julia.
Recording in progress.
What I have to add, well, first, it comes from my experience. Most of my life has been in private practice, and as a lawyer, as an advocate, doing the sort of thing that you all were pretending to do today. And I can say without any doubt, if you want it, all four of you have a future in this line of work. I would think all four of you, again, if you want it, would find top-line Western law firms that do this kind of work, would really be interested in hiring you. So stick with it, unless you want to do something else. You're all four really good at this. how could you do it better? People have already mentioned responding to questions. One thing I've learned working as an arbitrator, having stopped working as counsel, is when you hear a question from an arbitrator, that question is telling you something. It's telling you what he or she cares about. Sometimes it's just clarifying something unclear in what you said, but most of the time it's revealing what is really on that person's mind. And so you want to take the question seriously and do your best within the limits of the facts and the law that you have to work with to give an answer that is going to satisfy the arbitrator and hopefully advance your client's cause. The other general comment is, there's always a lot of things you can talk about in any case like this, and there were a lot in this problem that you had to deal with. Sometimes it's possible to find 2 or 3 or 4 points that really work for you, really help, and can maybe get the arbitrator to say, I don't need to worry about some of this other stuff because these issues pretty much decide the case for me. And if you can identify those in whatever facts you're dealing with, if you can identify those and focus on them so that you make the arbitrator's life simpler, it will help the client. It will help bring the decision to the decision you want. I think all of you can do that. This is something you get better at with time and practice. But there's nothing like finding that eureka point that you then just make sure that all the arbitrators understand and appreciate, and hopefully they go away thinking, well, that's why that side wins, is because of that point or the 2 points. At any rate, we have talked about this. This is a very, very hard decision because all 4 of you did just, I think, a really, really great job. And I was, all 3 of us were very impressed. But at the end of the day, someone's got to win. And that team is the Georgian team. So congratulations to them. And really, congratulations to the Serbian team. You guys were really good. And it was a pleasure sitting on this tribunal.
Recording stopped.
Thank you very much to the tribunal. Congratulations to both teams, of course, because as I think it transpires from many of the comments, and I think Tom was very clear about this, there's a future. There's a future. This is going to be over very soon. So congratulations to both teams. I'll see you in Boston. And now we'll move the tribunal backstage for a proper goodbye. And if we have Chris Campbell here, the director of the Moot, we'll bring him back on stage to have a final word of closing. So if Belen can help me on this, on finding Chris, that would be great. And both teams can, let me see if I can move both teams. Okay, we have Chris. Let me see if I can change the attendees, both teams. There we go. Yeah, there we go. Hi, Chris.
Hi, Ivan. Good to see you. Belen, good to see you.
What
Patricio is there somewhere too, I think? Exhausted, perhaps?
What person, who could give a better closure to the InterLaw Cup than the director of the Foreign Direct Investment Moot himself?
Well, you're raising expectations too high. I really just want to say that I very much enjoyed what I listened into. I want to congratulate all the teams, of course, especially the 2 teams in the final, and of course the Georgian team, which eventually prevailed. I want to congratulate the organizers, so the 3 of you, for really putting together a fantastic pre-moot. I think you've done a great job, and I think the teams really appreciate that and benefit from it. And of course, we benefit from it too, because they're going to be all the better in 10 days' time when we see them in Boston. So thank you very much also to the arbitrators who gave their time for this. And I'm very impressed with the finals panel that you put together there. Really some very renowned, famous, accomplished international lawyers. So
I'm sure they would
great
love to
job.
hear that. I'm sure they would love it if I send you backstage and you say that to them too.
Well, you can pass that. They know that anyway. They don't need me to tell them that. I just acknowledge it. But well done. Congratulations.
Well, thank you very, very much for taking the time of being here. We do this partly to support the FDI Moot and the FDI Moot students' preparation. Of course, we do it within our limits, and we had to confine this pre-moot to 16 teams only. But this is what we could manage, and we could manage it very well. I'm very, very glad to say we didn't have any truncated tribunals. We did a good job. So a final word for teams and coaches, and obviously also arbitrators to a certain extent. Not just see you in Boston, but also all the best of luck, not just for the FDI Moot, because the FDI Moot is going to finish very, very soon. 10 days, it's going to start. 15 days going to be over. Think about this in the longer run. We really hope this experience helped you in your preparation for the FDI Moot, but most importantly, that it helped you connect with other people. It helped you enhance your skills and prepare you for practice, because what's around the corner is not the FDI Moot, is actual practice. So thank you very, very much. And with this, we close the 2025.
Could we take a picture of the teams and the final panel?
Oh, we didn't?
We didn't.
I hope they did.